3608. And is Carl Lyon on the line? Carl Lyon?
Yeah, I'm here.
Okay. Mr. Blonsky, you raised your hand in response to my question about a continuance.
Correct. So the last time we were in court, we were waiting on an appeal letter from Oregon State. When I contacted them last week, they told me that they were on vacation and they still have not reviewed the appeal letter. So we have nothing. Okay.
All right. Well, I have just a few questions, and maybe we can address a few things today. So Mr. Vaughn, just to clarify, does he have a felony conviction?
No, I turned in background records for you.
Okay. And Mr. Lyon, did you see those?
Yeah, I saw that. I believe that they were originally felony convictions, but they probably got reduced down to gross misdemeanors.
Okay. All right. And then I just need a refresher from the both of you. Just looking at what was the residential time for each parent at the end of 2023, and then what the current time is now, what the residential time is now. So maybe Mr. Blonsky, you can tell me at the end of 2023 what you recall was the residential time and what the residential time is currently.
That was just weekends, so Friday through Monday. I want to say Friday from 6 to noon, and now it's Saturdays. Every other weekend is, Pendleton or Hood River, back and forth. We have an 8-hour visit on a Saturday in Pendleton and then a 4-hour visit in Hood River. But Mr. Lyon and I both spoke about it, and with the kids being on summer break, we were willing to negotiate a different time schedule.
Okay. All right. Thanks. Mr. Lyon, does that comport with your recollection?
Yeah, that sounds about right.
Okay. Okay, so from your perspective, Mr. Lyon, Mr. Blonsky is indicating that there's not much to review today because there's not indication about the appeal of the CPS finding. What's your take as far as efforts today, if there's anything to be done today?
Can you repeat the question?
Sure.
Sorry.
No, that's okay. It was a poorly worded question. Mr. Blonsky is indicating that there's not much for us to do today, so she's asking that the matter be set over until we have more information about the CPS appeal.
Yeah, sure. I'm fine with that.
Okay. As far as timeframes, I don't know what timeframes we're looking at as far as setting things over to look at the appeal. Do you have any idea, Mr. Blonsky, with the people you've spoken with?
Their deadline, they had 30 days to review an appeal. I was told that there was an emergency situation, so they got back to the office late. So I'm wanting to give it more time because working with Oregon, I've noticed that they're kind of delayed on responding. So I'm thinking maybe like 3 weeks.
Okay. Mr. Lyon, do you have any suggestions? Oh, Mr. Lyon, if you did speak, I didn't hear you. Looks like you're muted.
Oh, sorry. What was that again?
There was a suggestion by Mr. Blonsky to set it over 3 weeks to July 17th in hopes that the Oregon CPS folks would have some more input on the status of the appeal. So are you okay with that date?
I was just thinking that we could do like another month, just give it another 30 days. But
yeah, are you comfortable with that, Mr. Blonsky? Let's do that. We'll set it over to July 24th. Hopefully we'll get some more information and then we can take a fresh look at things and see where we're at.
I did have one question for you. Mr. Lyon said he had turned in some paperwork. I have not been served a copy yet. Is there a way that I can receive that copy at the clerk's office?
Which document are you referring to?
Just the last documents that he turned in. I don't know when he filed them.
I turned in the DHS final report. It's like a big document, about 26 pages.
Yeah, it looks like that was filed on June 17th. So as a general rule, Mr. Lyon, anytime that a party serve or file something with the court, a copy should be provided to the other party. So if you could do that, that'd be appropriate.
Yeah, I told the clerk to I don't know how to go about getting things served to Tara, but I told him that like a copy served, and that's all I really know.
Do you have her address?
I can get it, yeah.
Okay, so yeah, just a copy of that document that was filed on June 17th should be mailed to Ms. Jablonski, and then you should file an affidavit of service that you've filed on such and such, or you served her a copy via mail on such and such a date to such and such an address.
Okay.
Okay. Anything else? Mr. Lyon, anything else?
No, I'm good.
All right. We'll see everybody July 24th. That's Wednesday, July 24th, 9 a.m.
Okay, thank you.
Thanks.
All right. Thank you, Judge.
I'll ask if Cameron Miller is on the line.
Right here, Your Honor.
Okay. Welcome, Mr. Miller. And is Taylor Young on the line?
Yes, I'm here.
Okay. Welcome to both of you. And I see that, let's see one moment. See that Ms. Corey is on the line with us also. Welcome to you. We're on today for Ms. Young's motion for adequate cause to modify a parenting plan. And let me just double check as far as service. I had a question, Ms. Young.
Oh, yeah.
So let me just see who's speaking. Ms. Rhodes, Megan Rhodes. Can you
Yes, sorry.
please mute?
Yes, give me just one moment.
I'll take care of it. Thanks. Okay.
Your Honor.
Yes.
So I need to go down to the courthouse, and I need to the court called me, I think, about a week ago, and I need to switch. And like, I need to put my name as the petitioner and hers as like the respondent or something like that. And I still need to serve Miss Young. And then Miss Talia, if that's correct, I tried emailing you and contacting you to set payment up. And then, yeah, it's in an email somewhere. And then I also left you four voicemails. And then my hair particle coming from, who is that? LabCorp. They should have already emailed that to you too, out of Tumwater. Okay. Go ahead.
I've not received an email from you. I've not received an email from them.
Okay. I'll check up on that then.
I haven't received anything either.
I know I still need to serve you, and I need to go back down to the courthouse to switch paperwork around, they said.
Okay. So let me just kind of step in a bit. We're here on Ms. Young's motion for adequate cause to modify the parenting plan. I wanted to first check with Ms. Young as far as service. Did you serve a copy of the summons and the petition to modify on Mr. Miller or to Mr.
Yes, and he threw them in my stepmom's face.
Did you say that again?
He threw them in my stepmom's face and never responded.
Okay. And did you file an affidavit or declaration of service that the
Yes.
documents were served?
So none of that is true,
So
because
hold on, Mr. Miller. So Ms. Young, what I'm looking at on June 3rd, I see an affidavit or a declaration of proof of personal service. It says Angelia Barton served Mr. Miller on May 31st, 2 documents, a proposed parenting plan and a motion for adequate cause.
Yes.
What I don't see on that is that there was no service of the summons and the petition, which are necessary to move forward with any type of motion. So
I filled everything in with it and the proof of service.
So on the proof of service, it indicates that it says Mr. Miller threw the papers across the parking lot, but there's only 2 documents that are shown that were served upon him, the proposed parenting plan and the motion for adequate cause. So the boxes that the petition and the summons, those are not marked. And so when I read that, that tells me that he didn't get all the documents. So procedurally, we can't move forward today because he hasn't been properly served with those documents. And that's probably pretty frustrating for you because you go through a lot of effort to get things done. But at this point, we're not in a position to move forward with your motion for adequate cause and to modify the parenting plan.
Even if it's also been 3 weeks, more than multiple times, he hasn't responded with his hair follicle or anything.
Okay.
They keep pushing it and pushing it. There has to be some kind of consequence for him not doing what he's supposed to do.
So going back to the hair follicle, can you remind me the date that was ordered?
He's already ordered it.
And Corey, you may be able to know also.
Your Honor, the hair follicle is done. If LabCorp hasn't sent that over, I can't control that. All I can do is call them and have it sent it over. That's it, but it's done.
So when did you take the hair follicle?
3 weeks ago.
What date? What date did you take the hair follicle?
I'm looking. It would have been the 4th or the 5th.
Of June?
Honor,
Okay. Ms. Corey?
it was ordered on May 22nd by Judge Warning.
Okay, so it was an oral order.
I believe so. It's,
Okay, so let's see.
under the 522 motion hearing.
Okay, so on May 22nd, indicates the clerk's minutes say the court sets the matter over to May 29th at 9 a.m. The hair follicle test to be provided by then. So on May 29th, we had a hearing, and that was in front of Judge Basher. There's a discussion about the hair follicle test. Mr. Miller requesting the GAL to email her information so he can submit an ROI. GAL to provide information to Mr. Miller. Hair follicle test needs to be sent to the GAL. So this was discussed previously, from Mr. Miller. Did you send a copy as instructed and discussed by the court on May 29th?
I gave provider all the information for them to do it.
Did you send a copy to all the parties? That's kind of the key part. We don't care what the others are doing.
No, I
The
thought
onus and responsibility is on you.
correct. No, I didn't,
Why not?
because I thought that they were going to reach out and send it to her.
So when the clerk minutes say that Mr. Miller needs to send the hair follicle test to the GAL, what part of that do you not understand?
I thought I was supposed to give them her information and sign a release of information for her.
That was part of the discussion. Yeah.
Yeah, so then that's where I got messed up in.
So, Mr. Miller, are you in a position today to get a copy of the hair follicle results and email and also mail to Ms. Corey and to Ms. Young?
Yeah.
Okay, that's a court order that you'll accomplish that today. I'll do a bench order so there's no confusion. One moment. Do you need any email addresses to send or physical addresses to send that information, Mr. Miller?
Just the GALs.
Okay, Ms. Corey, can you share that?
Certainly, it's T.
Are you able to email it to me?
I have emailed it to you. Most recent email was May 29th.
Okay, I'll look for it.
Okay, so Mr. Miller, just so you're aware with the order that I'm writing or just wrote, it says Mr. Miller shall forward a copy of the hair follicle test taken on or about June 4th or June 5th, 2024 to Ms. Young and to the GAL by close of business today. Any questions on that order?
As of close to business today?
You have to do it today. You have to send it today. It has to be completed by the end of today.
Okay, so I'm at work right now.
Would tomorrow be easier, better?
Yeah,
okay.
Please.
So I'll amend that so it'll read June 27th. Okay, so that takes care of the hair follicle issue, Ms. Corey. Did you, or was that Ms. Young that spoke?
Oh, it's me. I was like, so do I need to go serve him another summons for the modification, or can you put, since he's here now, can we discuss a date for the summons or do I need to reserve him again?
Yeah, so the issue with service of all the documents for the adequate cause motion and the parenting plan modification, sometimes service is uncertain when and where that'll occur. So generally we don't set a date in the future. We wait for the service to occur. And then when you're doing the service, then you'd set a docket notice and setting it to a particular date. So I'll leave that in your hands to make a determination of what date that should be. And then then the documents can be served upon Mr. Miller.
Yeah, that's what we did when I did. I'm the one who set the 26th and the 12th for him to respond by the 12th. I did all that. That's why I didn't know that the papers weren't turned in, because I picked the date and everything.
Right, like I said before, there's 2 documents that were absent in the documents served upon Mr. Miller. So all those same documents he served before, and then the addition of the petition and the summons also have to be served upon him, and then give the date for the future. Okay.
Your Honor.
Yes.
With all the difficulties she's had with serving him, is it possible that she can serve him by mail? I believe that was approved.
Yeah, I don't think that, so the prior service was in person, and there's Mr. I believe.
He served me by mail the first time. He just dropped it off at my mom's house, and they used that.
I'm just looking for a pleading filed by Mr. Miller so we know his address.
It's there.
Okay, I've got a Rochester address. Mr. Miller, is that the correct address?
Yes, Your Honor.
Yeah, okay. Yeah, so Ms. Young, that's fine if you want to serve via mail, so you can mail that to that particular address. And then Mr. Miller, be on the lookout for those documents so you can get them, and then you can respond in writing to, so I know
Okay.
what your position is.
Am I also able to mail her or email her for my response?
Yep, that's fine. And you'll see that with the pleadings that she's filed, and it's looks like it's a Centralia address.
Yeah.
Okay. Other items to address today, Ms. Corey? Okay. I didn't hear you, but I read your lips and it said nope. It looks like you're unmuted, so I'm not sure what happened. And then Miss Young, any other items on your end?
So there's no other court date. It's just when I make a new court date.
Correct. And then Mr. Miller, any further items on your end?
No.
Okay. I appreciate you getting
And
that
one more
follicle
thing.
test forwarded to Miss Corey and to Miss Young.
One more
welcome.
thing.
Yes.
And on the pickup and drop off, we're not in Callis anymore. Can we move the drop off and pick up somewhere up here? He lives in Rochester and I'm in Centralia. We're driving 45 minutes away just to turn around and come back.
I would rather not.
So anytime issues with, there's a request to change a parenting plan or a provision of a parenting plan, there needs to be some type of written motion with notice to the other side. And so if, I'd encourage you at this point to see if you can talk about it and come to an agreement. If you can't, then there could be a motion and that could be addressed in the motion to modify the parenting plan also. So sorry, I can't help you on that one today. There just has to be that notice and opportunity to respond. Okay. All right. That'll conclude the hearing for today. Thank you. I'll ask
Thank you.
Maggie Sills, if you're on the line, if you'll say good morning. Okay, not hearing a response. Bradley Sills, are you on the line?
Yes, Your Honor.
Okay, good morning. And Ms. Heights, are you on the line?
I am, Your Honor. Thank you.
All right, very good. Thank you. Again, I'll just call up Maggie Sills. Maggie Sills, if you're on the line, please state your name. Maggie Sills. Okay, I'm not hearing a response from her, which is not terribly surprising because I show that there was service by email, not service by mail or personal service. So, Mr. Sills, was there an agreement? Is there an agreement on file between you and Ms. Sills to allow for service via email?
Not entirely. She's just kind of disappeared. She hasn't changed her address with the court. She changed her phone number. I've been blocked by her on social media, so I have no form of communication other than an email address that I knew about.
Okay.
Whether she even actively checks that email is unaware. I'm unaware of, but that's the only means of communication that I know of to try to get a hold of her at this point.
Okay. So as a general rule, when a party files an action or files some paperwork, they're required to put an address where they can be served. And the address that she included when she filed her petition and summons is that Silver Lake address on the Lake Road. Do you have that address?
Yes, but I know that she's not there.
Right. It's her responsibility to update it. And so if you serve her documents at that particular address, that's deemed adequate and proper service because it's incumbent upon her to keep her address updated for the court for all parties. So at this point, your motion to transfer the case to mediation and I think you alluded to a motion to admit the GAL report. We can't handle those today simply because there was service via email. Service by email only is allowed when the parties agree to it or the court orders it. And so neither of those two conditions have occurred. And so if you want the motion to be heard, and sometimes it seems like form above substance, I get it. And yet the rules are there for a good reason. So if you want the matter heard, you'd have to serve her a copy with your motion, giving her notice at that Lake Road address in Silver Lake.
So, Your Honor, I did drive up there and the trailer that she's living in wasn't there. So even if she's not there, it still counts as, you know, she was evicted from that property.
Yeah, it still counts as good service because, like I said before, it's incumbent upon any party that if there's a change to their address, they're responsible for updating immediately the court and the other parties of the new address. So it seems kind of silly. I get it. I hear what you're saying, that, you know, you send it there, she's not going to get any more notice than she got today. But
right, that's what I just really don't understand. I mean,
There's rules of service, and I get it. There's a rationale behind those rules. It's all a part of the due process, notice, opportunity to be heard, and we just need to follow those rules. So if you want the matter heard, we won't be. I wouldn't be able to grant you any relief today, based on the inadequate service, because there was not proper service. But if you want a server at that Silver Lake address and re-note it, then we can do that.
Okay, so I just have to go up to that trailer park and
You can mail it. And then you'd need to file an affidavit or declaration of service that you mailed it, or that somebody else had mailed it. You can't mail it. It has to be somebody else.
right.
Okay. Any other questions?
Can we extend this till next week?
Can we just extend this to next week?
Nope. You'd need to send out the document, file your notice of declaration, and then you'd need to do a docket notice to get on a proper docket.
Yes, sir, we'll do it.
Any other questions?
That's it. Thank you.
Sorry for the frustration. Okay. We'll look forward to seeing your motion in the future. Are you on the line today or present? Come on out, Ms. Roll. You can take a seat whichever side you care to.
Sarah Carter, not Central.
Thanks. So anytime that a case is filed, the case is filed under the petitioner's name that's filed, and so it doesn't change throughout. So I appreciate you letting me know that it's Carter, but it may very well be in the future that all future cases they use Troll.
Okay, as long as you know who I am.
Yeah, yeah. No, I appreciate that. Thank you, Ms. Carter. And then Sten Carter, if you're on the line, if you'll state your name, please.
Sten's not here.
So I just have to go through the process of calling his name to make sure that he has an opportunity, if he is here, to state his name. Okay, not hearing a response from Sten Carter. This is Mr. Carter's motion for finalization of dissolution. When I checked the file, there was not a declaration of service. In other words, he had noted it up, saying, hey, let's put it on this docket, but he hadn't provided any documents related to the purpose of the hearing. So what do you know, Ms. Carter?
So I'm the petitioner,
You are?
and I'm flying out tonight to go have him. I struggled getting him served, and so I'm going to fly out tonight.
Hello?
Sten Carter, are you on the line? Okay, go ahead, please.
I'm going to fly out tonight to Reno. They reside in Tahoe, and so we're going to meet, and I'll have this paperwork next week. So if we can, I'll have everything signed. He also needs to fill out the other paperwork that the facilitator went over with me.
Okay.
So
your plan is to fly out tonight, have documents, discuss them. If there's agreement, then he would sign, you would sign, and you'd be back here next week to turn those documents in.
yes.
Okay. I'm fine with that. So we'll set the matter over 1 week to July 3rd, 9 a.m. And then we'll look for, another option, just so you're aware, Ms. Carter, is that if everybody agrees and it's signed off on, then you could simply submit those on what they call the ex parte docket, meaning you give it to the clerk's office and say, hey, these are agreed orders, just send them back to the judge for signature, and then they can be signed off. And so we don't necessarily need to have it on a docket if you feel like there's some, yeah, so it's up to you. If you feel that there's some question whether or not he would sign off on the documents, then we could set it for a docket. But if you're fairly confident that he would sign off on it, then we probably would not need to set it for a docket, and you could just have those signed documents and turn them into the clerk, and they'll get them to one of the judges for signature. Okay. So at this point, we won't set any additional hearings. If the signing doesn't occur as anticipated, then you could certainly note it up for a docket and have the matter heard.
Okay.
Okay.
Thank you for your time.
All right. Thank you, Ms. Carter.
Welcome back to the.
And Ms. Rhodes, are you on the line? Oh, yeah. Ms. Holder, you're here. Great. Can you hear me? Good morning. All right. So today we are, and also I should note that Mr. Lawrence is present. So he submitted his report on June 21st. Just checking with the parties. Mr. Jensen, did you get a copy of his report?
Yes, Your Honor.
Okay. And Ms. Holder, did you get a copy also?
Yes, I did.
Okay. And then Mr. Lawrence, I think you had a comment.
Yes, Your Honor. I'm asking the court to not adopt my recommendations at this stage.
Okay.
When on last Friday, when I was done with the report and in the process of filing it, I was informed by Twyla Corey, who is the guardian ad litem in the John Pittman matter, that Mr. Pittman is a registered sex offender. I was aware of that, but he was dating Megan Rhodes. And it was my understanding, Ms. Rhodes provided me a copy of a text where she indicated she was breaking up with Mr. Pittman due to his prior criminal history. Ms. Corey indicated to me that it became aware to her that Ms. Rhodes and Mr. Pittman may have been wanting to just simply remain as friends until after the court proceeding, and then they were planning on getting married later this year. And that would have been totally contrary to what my feelings were with regards to the safety of the child, Nora. I sent an email out to Mr. Jensen explaining that I'm not going to be asking the court to follow my recommendation at this point. I sent another email out to Ms. Rhodes. In addition, I sent one to her attorney, Ms. Holder. And since then, I have had a chance to speak directly with Megan, who has indicated to me that she indeed has broken up with Mr. Pittman. I spoke with a partner of Ms. Holder, Glenn Slate, on Monday, and he indicated that they would be willing to do whatever it takes to try to satisfy my concerns on this matter. I spoke to Ms. Rhodes about the potential of her filing for a no contact order against Mr. Mr. Pittman, so that he have no contact with Megan nor Nora. And so he indicated that she was willing to do that. And so at this point, I'm asking the court to set this over for a period of about 2 weeks to give Ms. Rhodes a chance to go ahead and file for her no contact order and provide me with a copy of it so that I can reasonably determine that Nora would be safe.
Thank you, Mr. Lawrence. Ms. Holder?
Yes, I would be fine, and my client would be absolutely fine with a 2-week set over to address this issue. As I mentioned at the previous hearing, I represent both Ms. Rhodes and Mr. Pittman, so I would not be able to represent either one of them at a hearing for a protective order, as it would be a conflict. Based on the information that I have seen, and I would like the court and Mr. Lawrence to be aware that, or to perhaps give some guidance. In the event, should Ms. Rhodes not allege anything at a protective order hearing that would rise to the level to meet the legal standard of stalking, harassment, coercive control, or anything of that nature under the statute, is there anything that Mr. Lawrence is aware of that perhaps I am not, that Ms. Rhodes could base a protective order off of?
Well, it seems pretty obvious, Your Honor, that if he is a convicted sex offender and is hanging around a woman who has a 1-year-old daughter that is the subject of this proceeding, that there is an inherent risk to this child.
I would also like to just clarify that if Ms. Rhodes were to go to a protective order hearing, in the event that she was not able to get a protective order, I would like the court and Mr. Lawrence to note that in the event she's not able to secure that she has done, she has willingly pursued one. And I would like the court and perhaps Mr. Lawrence to note that, in the event that she is not able to secure one, that would go toward Mr. Lawrence's report, and that he would note that she was more than willing to, and she in fact did pursue a restraining order or a protective order.
That doesn't satisfy my concern at all. If there isn't a protection order or no contact order, I may have to reconsider my recommendation totally and consider recommending that the court award custody to Mr. Jensen. I was assured by Mr. Slate.
Excuse me, Mr. Lawrence. So applauding during the middle of court is wholly inappropriate. yeah, don't do that again. There's not to be shown. The thing is that there's attempts to sway the court in different ways, and that it's wholly inappropriate for there to be applause. And I'll just strongly warn you, do not do that again. And the warning goes to obviously everybody. If you can't control yourself, you can obviously remove yourself from the courtroom. I won't tolerate that. That's wholly inappropriate. I don't know where you get off thinking that it would be okay, even in the first place, to applaud. This isn't a concert. There's not, these are people's lives. These are children. And so do you have any questions about the court's directive to never do that again? Do you have any questions? Pardon for the interruption, Mr. Lawrence, go ahead.
Anyway, I would have to reconsider my recommendation and potentially recommend to the court that the custody situation be changed to Mr. Jensen. I realize that he has some issues himself, but I'm extremely concerned about this contact between Mr. Pittman and Nora.
Okay. Ms. Holder, any further comments before we hear from Mr. Jensen?
Yes, again, because I'm not able to represent either Mr. Pittman or Megan Rhodes at a presumed hearing, I just want Mr. Lawrence and the court to just be aware that it could potentially be a hard burden to overcome for that preponderance of evidence standard, and that I do not want Ms. Rose being penalized if she's not able to overcome that burden.
Thanks. Mr. Jensen, any comments?
Yes, I just asked Megan's already lied multiple times to the court and to Mr. Lawrence about the situation. So I asked in order to be put in my care until she could prove otherwise that she had not been around John Pittman.
Okay.
His machinery has still been up at her house, so they've still been having contact.
What's your position regarding Mr. Lawrence's suggestion of setting it over 2 weeks to allow a potential no contact order to be entered?
Well, that's what I'm saying. For this 2 weeks, can I have her care? And then if she does get it, we can go back to doing what we're doing now.
Okay, I'm going to hold off on that invitation to allow this process to move forward. If we come back in 2 weeks and we learn certain information, there may be some changes in the works at that point. But at this point, I'll hold off. Let me just ask, Ms. Holder, has your client signed a document under penalty of perjury related to her relationship with Mr. Pittman?
Yeah, I'm not sure if she has or not beyond what she has talked to Mr. Lawrence, but I would happy to get a declaration or affidavit and have my client sign that and send it over to the court. And just so the court is aware and Mr. Lawrence is aware, that machinery was moved before 8 a.m. yesterday morning. It is no longer there.
All right. So it sounds like there's no prohibition or no objection to setting the matter over 2 weeks to the 10th of July, 9 o'clock in the morning, to allow exploration and possible entry of a no contact order prohibiting Mr. Pittman from having contact with Ms. Rhodes and the child. We'll see where that goes, and then we'll be back here to review that, and we'll entertain any motions such as changing custody to a different parent, specifically Mr. Jensen. We'll address that in 2 weeks.
Thank you, sir.
Thank you, Your Honor.
A different
Thank you,
document
Mr.
to attend
Lawrence.
to where her presence is needed. So go ahead, please.
Thank you, Your Honor. Can we call number 4 on the docket? That's Vaughn and Kiyoshi. I see that it's noted on the docket just for child support, but my understanding was that we were also going to be entering a final parenting plan as well. I just wanted to check if the parties had come to a full agreement on that. If not, we may need to set this over.
Thanks. Alexandria Vaughn, are you on the line today?
Yes.
Oh, there you are. Okay, great. Thank you. I didn't quite hear you. And then Zachary Kayoshi, are you on the line?
Here, Your Honor. Here, Your Honor.
All right, very good. So there was some orders related to child support, and I'm just curious, last time we were here, I believe that Ms. Vaughn had not seen a copy of those proposed child support orders. So at this point, Ms. Vaughn, have you seen those?
Yes.
Okay. Do you have any concerns on those orders?
Nope.
Okay, Mr. Kayoshi, have you seen those proposed child support orders?
Yes, Your Honor.
And do you have any concerns related to them?
No.
Okay. And let me just pull those proposed orders, Ms. Looney. Let me just get them out of my stack here just a moment. Okay, so I have worksheets and I have the child support order. Having heard from each of the parties and hearing no objection, I'll sign off on those.
Thank you, Your Honor.
Okay, I've signed off on both of those. There was also a parenting plan proposed order that I have in my possession, and that was submitted by Ms. Vaughn. It looks like it was signed by her and also by the guardian ad litem, Ms. Fellows, and also by Mr. Kayoshi.
Yeah.
Mhm. Yeah, the clerk just reminded me that on June 5th, I signed a final parenting plan, and I'm just curious if there's a distinction between this proposed order I have in my hand and the one that was signed previously. Do you have any insight into that, Ms. Vaughn?
At our last hearing, I had filed the last hearing we had, I had filed a proposed temporary, and we had discussed it potentially being mimicked for the final, and you had set this hearing. And so I submitted the same document with like the little changes Dad wanted that we agreed upon, and had it re-signed and sent back.
Okay. Mr. Kayoshi, do you have input on that same issue?
No, Your Honor. So that, I guess the one she submitted after the last court hearing is the one we both agreed on. There's with some small changes, but that's the final that we agreed on.
Okay, that sounds good. And Ms. Fellows, are you on the line?
Yes, I am, Your Honor.
Any comments about the amended final parenting plan?
No comments. I signed that parenting plan as well. And I'm actually would like to give these parents kudos for coming together to do the parenting plan together.
Okay, great. Yeah, I echo that same commendation. So good work, both of you. And then, so what I'll do with this proposed parenting plan, I'll just add to it in the caption amended. So we know that this one is a later in time one that supersedes the prior one that was signed. So with that said and done, I'll go ahead and sign off on this parenting plan, which is an amended final parenting plan. And then child support orders will be filed and signed today. Anything else that either party or any of the parties I need to address today, Ms. Looney?
No, Your Honor.
Okay, Ms. Vaughn?
Is that the one that you just signed? Is that the one that I have marked as the final order?
I'm responsible for his life. You don't make these stupid questions. If you've already jumped,
Kathy Howard.
You already know what happens to the balloon.
Kathy Howard.
He was worried about the weight.
You'll need to mute your phone, Kathy Howard. You need to mute your phone or your device.
Situation would be with the balloon.
Okay, doesn't know how to do that. So the prior one that was signed on June 5th, that was marked final parenting plan. This new amended parenting plan is also marked final parenting plan. So the only difference is that, I guess the difference is that you both agreed to, and then the word amended, and this is the parenting plan that I'm signing today.
Okay, I just wasn't sure because I know the last one I had submitted said temporary. It was marked temporary, and then this one I marked as final.
Yeah, I think we used some whiteout last time and made it final last time too. Okay. All right, so I signed off on those three. Mr. Kayoshi, any final questions?
No, Your Honor.
Okay, great. Appreciate everybody's effort. If you need copies of those documents, certainly you can check with the clerk and get copies of them. All right, otherwise that'll conclude the hearing. Thanks.
Thank you.
Thank you.
I think it's Leanne Jones and Brian Gentges. Are you on the line, Leanne Jones?
Your Honor.
Okay.
Yes, I am.
Great, very good. And then Brian Gentges, are you on the line? And the last name, I may be mispronouncing it. It's Jentges, Gentges?
Yeah, it's Gentges.
Thanks. Brian Gentges, are you on the line? Okay, I'm not hearing any response from Mr. Gentges. There's child support orders that were proposed by the state, setting incomes at $858 for the father and $2,035 for the mother, with the father paying $50 for each child for a total of $100. So I'll hear from you, Ms. Looney.
Yes, that's correct, Your Honor. The father is getting SSDI disability, so his actual income is used. We did impute Ms. Jones at 32 hours a week at minimum wage because she's currently on TANF with the children. Mr. Gentges would have a $100 statutory minimum payment, $50 per child. We're asking that begin in February. That is the month the children began receiving TANF benefits.
Okay. Ms. Jones, do you have any comments related to the proposed orders of child support in the worksheet? So, Ms. Jones, if you're speaking, the audio is not coming through. I'm not able to hear you at this point. It looks like you're unmuted. All right, still not able to hear you. Okay, Ms. Jones, one thing you may try is just moving to a different location, or you could sign off and sign back on, and we can readdress your case once you get back on the line.
Okay. I don't. Okay.
There you are. I can hear you. Okay. Yep, so,
okay. I
yeah,
don't
so
know
you're
what's
good.
going on with my phone. I'm sorry.
It's okay. So there's a child support order and a child support worksheet that Ms. Looney, on behalf of the state, filed. Did you get copies of those documents?
I did.
Okay. Do you have any questions or concerns related to them?
No, I don't believe so.
Okay. And then Ms. Looney, as far as the copies of these documents were provided via mailing. Okay, I see the proof of service there from June 3rd. I see that. Okay, great.
Yes, thank you.
And then just related to that, so I'm a little bit concerned or confused, and you can maybe help me here, Ms. Looney. As far as I didn't see necessarily a motion for child support. I see proposed orders that were filed and some sealed financial source. Was there a motion filed?
Your Honor, I believe we filed our proposed orders in response to the documents we received on May 24th, finalization of parenting plan and child support notice from Ms. Jones, and we filed our documents in response to that.
Does that strike you as a bit odd procedurally? If there's not an agreement between the parties?
We have done that in the past, Your Honor, but if we need to file a separate motion, we can do that.
Okay. All right. Let me touch base with Ms. Jones. You also submitted a proposed parenting plan. You filed a petition, for dissolution, including a parenting plan and the like. And it looks like you provided notice to Mr. Gentges related to, you gave him a family law docket notice, and you gave a family law docket notice to the state. Did you send any documentation as far as a proposed parenting plan to Mr. Gentges?
Yes.
And
he actually, I'm sorry, he agreed to the parenting plan.
did he sign off on it?
Yes.
Okay, the document that I have shows just your signature on it, not his.
Okay, that I don't know how that happened, but yeah, he's in agreement for everything.
I'll show you. I don't know if you can see this. This is the last page of the document that was forwarded to me. So it looks like you signed it. Did you sign it twice, or did he sign that? Because it has both your names under.
Okay, maybe that's how. So okay, I can't really see that top one, but it looks like the top one is his signature, and then okay, the top one's mine, and then underneath that,
yeah,
that's supposed to maybe I don't know what it did there.
Yeah, so it's a little confusing to me because it said, there's signatures, there's a signature line, and below each it has your name. So the it's not really clear to me whose signature that is on the second line down.
So I guess it's in the proposed parenting plan.
Mm-hmm. Yeah, that's what I have. This is the document I'm looking at.
Okay, so how would I go about fixing that? Would I need to go and refile everything? Because he's agreed in everything.
Yeah, if there's agreement between parties, any documents that are agreed can be signed by both parties and then submitted to the court clerk, and then the clerk will give them to the court to sign off on.
Okay. Yeah, because he's I don't know what happened. We sat there, he signed I don't know. I'm sorry. The person who helped me with the document is messaging me, and it's my PCAP worker, and she had said he signed it. The facilitator had seen it as well.
Yeah, I mean, I tend to agree with you that he likely signed it, but the paperwork indicates that the person who signed it was you, and so there's a bit of ambiguity there. So we try to avoid that with any type of court order.
Yeah, no, I understand.
Okay, so what I'm going to do, I'll sign off on the child support worksheet and the child support order. I think that's fine. Notice was given to Mr. Gentges. He's not present. I think that's fine based on the employment security data and the imputation of incomes. I think that's fine. As far as Ms. Jones, the other orders, you submitted two proposed orders. One was a parenting plan order. The other was kind of a final order of parenting plan and child support. So both those documents purport to have, well, the one document has two signatures on it, which I assume is his and yours, but the other document only has one signature, which appears to be yours. So
okay.
If there's any agreement on that, then both of you could sign it, and then you could submit it to the court. If there's not agreement, then you'd have to note it up for a motion hearing, and so the court can make a decision on it.
Okay, yeah, I'll get the papers and I'll fix it and file it with the court.
Okay, that sounds good. I've signed off on the child support order and worksheet, so those will be filed. The others, I've given back to the court clerk, and if you need those pleadings, you could swing by and pick them up, or you could submit new ones.
Okay, all right, thank you.
Okay, all right.
Thank you, Your Honor.
2108, both parties are in the courtroom. So we have Mr. Ruby's here. You're Mr. Ruby, correct? All right, very good. And you're Ms. Granzo Carranza.
Correct.
Okay, very good. All right. Also, we have Ms. Turnbull, who's the guardian ad litem. Ms. Turnbull, are you on the line today?
Yes, Your Honor, I'm here.
Okay, great. Thank you. Good morning.
Good morning.
So in reviewing the case in preparation for today, I reviewed a guardian ad litem report that was, I believe it was emailed yesterday, well, earlier this week. And I just wanted to confirm with Mr. Ruby, did you get a copy of it? Okay, he did. And then Ms. Granza, did you get a copy of it?
I got it yesterday via email.
Okay, I think that's when I got it too, was yesterday. So, you know, there's a lot of information in that report related to the three, Bethany, Anna, is it Livea?
Correct.
Livea, okay. And so I don't know if you've had enough time to read and digest that, or if you're in a position where you feel like you could move forward with the hearing today, or if you need more
Your
time.
Honor, I was actually thinking about maybe asking for a continuance because I have a lot of things that I'm new to this part, and with the case with Bethany and Anna, I've been really poor on my attendance and how I've handled that case.
Mhm.
Now we have a new case with our third child, and there's two separate cases. I would like to know if there's a way to join the two cases so we don't have two separate cases going on. I mean, it's the same two parents and there's three kids instead of two. I feel like it would be easier on the court's part as well as our part with only having one case number instead of
Sure.
two case numbers.
Sure.
Again, I do have documentation to turn in regards to some of the allegations that on my part, and I have quite a few different parties that need to be served, and I'm kind of going at this blindsided. I don't have help or anything, so I'm just trying to do right this time. My recovery is my biggest part. My kids come first, but I have to take care of myself, take care of my kids. So my recovery, and then I got my mental health on top of it. So I'm one day at a time is what I'm doing. I got all my papers and everything for both court cases here from start to finish with Bethany and Nana. Levea's is all right here, but I have documentation from, like I said, there's some allegations that have been that I'm not sure how to word it accurately, but the allegations that have been made against me, I have documentation to turn in to show otherwise.
So you want to be able to respond to those
Exactly.
allegations? Okay. All right, Mr. Ruby, what's your vantage point regarding the guardian ad litem report and moving ahead today, or maybe continuing?
I'm all good with it. My only concern is she has missed the last court date she was supposed to be here towards, has made no contacts to any of the kids. She's supposed to be going to do that 2-hour visits twice a week and has had no try to do any of it. So I'm just like,
Okay. What's your position regarding a continuance to allow additional information? You know, for example, the guardian ad litem submitted her report and has information in there. Ms. Carranza wants to respond to that and provide more detail. And are you in a position where you want to provide more detail also?
I'm good with the continuance.
Okay.
Because I was also trying to bring Levea into our other case as well to make it easier.
Okay, sounds like you're both interested in just having maybe just a one cause number and having just merging them together. We call that a consolidation order. Ms. Turnbull, do you have any concerns if we were to do a consolidation order?
No, I think that'd be appropriate.
Okay, so what I can do, if it sounds like the parties, I think that'd make life simpler and just have one cause number. I can draft an order of consolidation, consolidating it into one case. Madam Clerk, do you have any suggestions as far as which case should, as far as cause number should remain? Oh. Okay, so the 2022 cause number would continue on and the 23 would be subsumed. Okay, let me just write that down here so I don't forget that. And so they're both now threes. Okay. Okay, yeah, I'll do that. Ms. Granza, you had your hand raised?
Yeah, Your Honor, in regards to the visitation with my children, there is an active CPS case, but none of the three kids are involved in that active CPS case. The active CPS case is in regards to my my fourth child, Raina, who's not a party to this case because she has a different father.
Okay.
I've been in contact. I deal with CPS on a daily. Like
Okay.
I have a dependency case going on to get her back, and that's part of the documentation I'd like to submit to you, this
Okay.
court. So it's all being cross-referenced.
Okay.
There's a restraining order or a protection order between me and Marcus. So to be able to make contact, to be able to see my 3 kids is impossible.
Does sometimes no contact orders will have a, so let me finish. Can I ask you a question? So sometimes no contact orders will have a provision or exception that allows a third party to communicate regarding needs of children or visitation of children. Does that
That
no
third party
contact
was-
order? So let me finish my question.
Sorry,
Does the no contact order have a provision that allows for that?
not to my understanding, no. It states that contact can be done with CPS, but I've talked to CPS about it because there's no case with the older 3. They won't supervise the visits.
Okay. So where that no contact order, do you have a cause number for that?
Yeah, it is the cause number that it was received February 20th of 2024.
Okay, let me just pull it up here. Taking a look at the second document. The first document I looked at was signed on February 23rd. It's a temporary family law order. And it makes reference to a restraining order. So I just need to find that. I'm assuming it's this document. You by chance, do you have a copy of that document with you, Ms. Carranza? Are you looking at it right now?
Yeah.
What page page does it show that there's, what does the caption say on the top right corner of the front page? Just
Every
go to the right side of that.
immediate restraining order, ex parte, and hearing notice.
Okay.
It
And what's the date on the top right corner? There's usually a stamp.
It was filed February 13th, 2024 at 9:54 a.m.
And is that a petition or an order? Okay, so I'm looking at that order. It's dated February 13th, 2024. Restrains Samantha Granzo Carranza, protects the 2 children. The restraints are the following: do not disturb the peace of the protected person or any of the children. Do not, that's it.
Which on my part confuses me because with all our other, since at the very beginning of the case, the very first restraining order, I wasn't allowed no contact, like at all.
Yeah.
And they were supervised visits. And then I keep getting told I'm allowed to video chat with my kids, but then that how am I supposed to video chat if there's a restraining order between me and the other parent? I was absent at the last court hearing, and I do apologize for that. I have multiple court cases going on, and my court dates kind of overlapped each other. I thought it was the 18th and the 19th, and it was the 17th and the 18th, so I do apologize for that.
Okay, so the only, and Mr. Ruby, you can chime in also, it shows the only restraint that I show from that February 2024 no contact order is the restraint upon Ms. Granzo Carranza is to not disturb the peace of the protected person or any of the children listed.
Yeah. That's
your understanding?
Yep.
Okay, so I don't know if there's any other orders out there, but this particular order, that's the single limitation.
Am I able to, can I ask a clarifying question since we're not able to communicate outside? And
So when you say that you can't communicate, where does that prohibition?
Well, I was understanding my understanding is there was a restraining order between me and Marcus. I wasn't allowed to have any contact with him at all either.
Is that in a different order?
No, that's just the way I understood this one.
Okay.
And it could be just a misunderstanding on my part from the very beginning of the case to this part.
Okay.
At the very beginning, it wasn't a good situation at the 2 years ago. And a lot's changed and a lot's happened in the last 2 years.
Okay.
So I'm just.
So Mr. Ruby, do you know of any other no contact orders?
There was a restraining order put in place back in 2022 that I believe you put back in effect when she missed the last court date.
Okay.
That was my understanding, which is why I haven't made contact because I don't want to get in trouble and mess anything up more than I kind of already have.
A lot of moving parts here. So let me just double check to see if I can find any indication as far as any other restraints. And Ms. Turnbull, also, if you have any information that you'd like to share that might be of help, I'd certainly welcome that.
I believe were multiple restraining orders, and so I appreciate there may be some confusion. And it may be helpful to clarify at this point what we need to do going forward.
Right.
And also, you know, what the definitions mean. I think, you know, it may not be clear to Ms. Carranza what the definition of disturbing the peace is.
Yeah. So on April 17th, we were here. Mr. Ruby was present. Ms. Carranza was not. And at that point in time, Mr. Ruby was awarded primary custody of the children, and Ms. Carranza was to have professionally supervised visitation 2 times per week for up to 2 hours per visit. And then just to make sure that you're not under the influence, that was the supervisor's role. And then Mr. Ruby's obligation to pay child support was terminated as of the date of the order. And then Ms. Turnbull, the JAL, was directed to investigate and write a report, which she has. So that's kind of where we're at. I haven't thoroughly looked at the cases, because there's 2, to see if there's other restraint orders or no contact orders. So I can't give you any advice on that. Actually, I'm prohibited from giving you advice. So I would just encourage Ms. Carranza to look at very carefully all the cases to see what restraints there are or may be. But the one that you referenced, that February 13th, 2024 restraining order, the order restrains you, and the restraint not to disturb the peace of those children. It's kind of squishy what that means, right? But there's no prohibition from communicating with a fellow parent to discuss visitations. Right now, the visitations have to be professionally supervised 2 times per week, but you could communicate with him or have a third party communicate with him to make those arrangements so that the kids can see you and you can be with them.
Professional supervised visits, like, would that have to be like an agency? Could it be like a professional? I think of like an agency, but is there a way to maybe get some? I don't have anything. I'm on the ABD program, so in a sense, I get a form of disability, so that's my only income right now. It is just me. I don't have any of my children right now to have. Well, I mean, child support, yes, but I mean, there's no kids in the home, so my income is, you know, for paying bills. I mean, I pay my bills and I'm broke. Right. So I have no way to pay for a supervisor. With my youngest child, I am granted visitation, and that's what documentation that I'd like to submit to the court, so you guys can see from the CPS side to this side. Is there a way to maybe change it from professional supervised to like maybe a relative or a family member that Marcus agreed that he can pick whoever does the visits? I just know I haven't seen my older 2.
So let me go ahead and answer your question. Yes, there is a way. There's a court order from April 17th that says there needs to be professionally supervised visitation. If you want to change that, the way to do that is file a motion with the court, submit a copy to Mr. Ruby, and then he can respond, and then we can have a hearing on it to make a determination. But until that time, until you've submitted the motion and the case has been heard, then that order from April 17th would still be in effect, requiring the supervised visitation. But the means to change it would be a motion to change supervisor or change supervision level. Does that answer your question okay?
Yeah, I just
Okay. Mr. Ruby, do you have any questions at this point?
No, you don't.
So just to make sure, we have the GAL report, so both parties are interested in providing additional feedback on that. And then there was also, Mr. Ruby, it looks like you had filed a motion for a parenting plan, and you had served a bunch of documents to Ms. Carranza. And there's a big long list. There was 2 things. One item was missing, which was the petition to change the parenting plan. So you'd served all the documents, but I noticed there was one missing.
Okay.
So there's the petition. So we'll review that. And then Ms. Carranza, you had submitted a motion for a parenting plan, but I didn't see a copy of a declaration of service or declaration that you had served Mr. Ruby that. So just wanted to make sure you're aware of that we wouldn't be addressing that today because there has not been service.
I was just talking to the person that served him in regards to that is my bad. I do apologize.
Okay.
So
Just want to let you know that's why we're not going to be addressing things further. So at this point, with both parties desirous to submit additional information related to the guardian ad litem investigation and report, generally we allow a 2-week set over. That would allow both parties to submit declarations from your vantage point that would elucidate any issues that are brought forward by the GAL. So if we look at a 2-week time period, today being the 26th, that would set it to July 10th. Would July 10th be a day both of you would be available?
Yes, sir.
Mr. Ruby's available? Sure. While she's checking with that, Ms. Turnbull, are you available on the 10th of July?
Yes, I am.
Okay, great. Thank you.
Yes,
So she's available on July 10th, Ms. Turnbull said.
I'm gonna say it'll work if for some reason because I have another court case going on, and this is what happened back in April with my court case got mixed up together. I'm gonna say yes. If for some reason I'm just gonna say yeah. I'll make it work one way or another. I will make it work.
Okay. All right. So we will set the matter over for review of the guardian ad litem report with additional input from both parties. That'll be on Wednesday, July 10th, 9 o'clock in the morning. Yes.
Okay. Your Honor, in regards to the professional supervised visits, I do have a PCAP worker, and she's a mandated reporter. Is that an option for her to maybe supervise my visits?
So my understanding with a professional supervisor is that they're paid for their services, and there's a particular training that they've undergone.
I have for my youngest, I actually have a visit with her today at 1 o'clock. So that's why I was saying I understand.
So in response to your specific response to your question, I don't know. What I'm concerned about is that there's a professional there supervising the visits, that they will intervene if they need to. They'll take notes. They'll be aware. They'll notify the court of anything that's untoward. And good also.
No, I'm very aware of how the visit specialist works.
Okay. So that's where we're at. So I think we'll be back in 2 weeks.
I say we're also in contact with the CPS workers as well. I can talk to her and see if there's maybe something they can do, because that's, I believe, where she's supposed to have her visits with them at.
Yeah, the idea is that the desire is not to prevent visits from happening. The desire is to make sure that everything's on the up and up and the children are safe. So if Mr. Ruby feels comfortable with a professional supervisor being a PCAP worker, he could certainly chat with her. And if he feels comfortable, that's great. Otherwise, I think it needs to be a professional supervisor who that's what they do for basically a living. That's their employ.
Okay, I'll talk to my visit specialist that monitors my visits with my youngest.
Okay, so we'll be back July 10th. Make sure when you do submit your information, your declarations related to the GAL report, that you submit it with the court and also submit a copy to each other, and to the guardian ad litem.
One quick clarification in regards to the stuff for Livea. Since the cases are being combined, do we have to serve the state as well when we file?
Good question, Ms. Looney. Do you have an input on that?
Yes, Your Honor, we would need to be served. We will need to have information on the parenting plan so that we know what we may need to do regarding child support.
Yeah, it's a good clarifying question. Thank you. All right, I think that'll conclude things for today. Thanks. Reporting purposes. And so, you're Terry Kempf and you're Robin Kempf. Is that the correct pronunciation, Kempf?
Yes.
Okay. All right. Kind of struggled with that one. So this is on. So what I saw, the most recent filing was a motion to dismiss that was signed by both parties. Correct. And I just need to confirm that both of you are comfortable and want to dismiss the action.
Yes.
Yes, correct.
Okay. And there was, and just to confirm with Ms. Kempf, there was a default order that was entered on June 14th, and you recognize that?
Yes.
Okay. And notwithstanding that, you still want to dismiss the case?
Correct.
And Mr. Kempf, is it your desire also to dismiss the case?
Yes.
Okay. And do you have a proposed order of dismissal there?
The clerk told me to keep this and bring it when I filed with Monday.
Sure. And has Ms. Kempf seen that? Have you seen that document, Ms.
I don't
Kempf?
think so.
Okay, I'll take a look at it and then
Is it the same one that okay.
I'll look at it and then I'll let you take a look at it too. Then once you've
signed the other one.
Okay. Yeah, once you've signed it, then just pass copies of both copies down to Ms. Kempf so she can look at it and feel comfortable so she knows what it is.
Yes.
Okay, and are you comfortable with that?
Yes.
Okay. Do you mind just handing that up to the clerk and she'll pass that forward to me? Okay, I've signed off on the order dismissing the action, so you can work on your marriage.
Perfect. Thank you.
Okay, thanks. Good luck. Looks like Mr. Cox is here. Come on up. Take a seat. Good morning to you. And is Destiny Peters Ritzenthaler on the line?
I'm here.
Okay, welcome to you. This is a motion brought forward by Mr. Cox for a motion for temporary orders, including a parenting plan and a restraining order. Is that correct?
Yeah.
Ms. Peters Ritzenthaler, I see that there was service of those documents to Mr. Terry Ruff, who was a substitute service on June 2nd and June 5th, respectively. And then one thing that I always look to see if both parties have their voices heard. Here, I know what Mr. Cox wants because I read his motions, but I didn't see that you had filed anything. Have you filed anything in the case so I know what your position is?
I have been working on it. I have been back to back with baby appointments because I am about ready to give birth. So I haven't had the chance to turn in my portion yet.
Okay, when's your due date?
Next week on the 4th.
On July 4th, okay. Okay, and then Mr. Cox, you're asking for some restraints related to Mr. Ruff, correct?
Yes.
Okay. And the child is 2 and a half?
2 years, 2.5 years old.
2.5, okay. And then you're also asking in your motion for a kind of a 50-50 parenting plan if Mr. Ruff's not present.
Yes.
Okay. All right. So here, Mr. Cox, Ms. Peters Ritzenthaler is asking for, it sounds like, if I'm correct, that you're, Ms. Peters Ritzenthaler, you're asking for additional time to respond?
Yes.
So with that additional time and then your due date on July 4th, we may be pushing things if we were to set it over one week, because that would be July 3rd. And then if your due date's on the 4th, then you'd need some time to recuperate after giving birth. So we would probably be looking at the end of July for timeframes. And I don't know what your respective feelings are as far as timeframes.
I mean, I can't really control it, so it happens. I'll just have to deal with it.
Babies do what they're going to do, right?
Yeah.
Yeah.
Can't really control that one.
Right. So, okay. Are you asking for any immediate or temporary relief at this point, Mr. Cox?
I'd at least like to be able to see my child, because at the moment she's not allowing me to have any access to my son.
Okay. Ms. Peters Ritzenthaler, do you have any comment on that?
There is currently a protection order against Mr. Cox that was placed back in December.
Do you have a cause number for that I can maybe take a look at that?
The case number was 23.
Okay, so that protection order is dated December 18th, 2023, restrains Anthony Cox and also protects, protects Ms. Peters Ritzenthaler and also Levi, who at the time was 1. And the restraints are cause no harm to either party, no contact to either party. So that's that order's in effect. So you've brought a motion to basically address issues and to allow that visitation to occur. Yeah. So I probably what needs to happen is that we need to have Ms. Peters Ritzenthaler's response submitted and then come back for the hearing and address that with hearing from both of you. And then that protection order could potentially be modified or not, which if modified could allow for contact with you and the child. So I appreciate Ms. Peters Ritzenthaler notifying me of that. So that, I think that answers your question.
Well, I knew there was a protection order. I was just, wondering if there's a way that I can petition to get it dismissed.
Yeah, I think what, so this order, let's see its time frame.
It's 1 year.
Thank you.
You're welcome.
So there's an important provision within the order itself. It talks about custody granted to Ms. Peters Ritzenthaler, but it says subsequent family law matter may modify this custody and visitation order. So that's pretty standard language. There's kind of that initial emergency, if you will, order, protection order that's put in place.
Yeah.
And then it has that caveat language that this family law case could potentially modify that if the court deems fit.
Okay.
Okay. So I wouldn't be in a position to make any changes with it today. But once we've had a hearing potentially or not, it kind of depends what the decision is, that could be modified, allowing visitation.
Okay.
So timeframes, let me just touch base with Ms. Peters Ritzenthaler as far as your timeframes. Do you have, it's hard to know how you're going to feel after delivering and caring for the baby, but do you have a general time frame that you think would be a good time to come back to address the proposed
30
parenting
days,
plan?
if possible.
Say that again, please.
30 days, if possible.
30. Okay. All right. So that would be the 24th of July, Wednesday at 9 a.m.
That works for me.
Okay. And does that work for you, Ms. Peters?
Yeah.
All right. We will set both motions brought by Mr. Cox, the motion for the parenting plan and the restraining order, both will be heard on July 24th. And Ms. Peters, we'll look forward to receiving your documentation prior to that date, and then you'd need to serve a copy upon Mr. Cox, and then we'll be back on the 24th to make some decisions on the motion.
Alrighty.
Any questions?
Nope.
Okay, great. That'll conclude the matter for today. Thank you.
Yes, sir.
Thank
All right,
you.
welcome to you, Mr. Phelps. And is Emily Dietrich on the line? Ms. Dietrich, if you're on the line, please state your name and so I know you're here. Okay, so let me touch base with you, Mr. Phelps. Mr. Phelps, this is your motion for summary judgment regarding parentage, correct?
Yes, sir.
When I looked at the information in the case file, I always look for service. That's one of the first things I look for. And it looks like that you served upon Ms. Dietrich an acknowledgement of parentage. But what I didn't see was that you gave her a copy of your motion for summary judgment. Did you give her a notice of the?
Yes, I gave her the whole, well, I didn't, a third party did, but
Yeah.
I got 3 packets from my lawyer. That everything I filed with the courts, I gave to her.
Okay. So the way that I generally know that a person serves a document or what documents they served is via that proof of personal service. So when I looked at that, I saw the following. I see that you served her an acknowledgement of parentage, and then there's another box here at the bottom that's not checked, but it says FL Parentage 301, 307, 312, 313, 314, 15, 16, 329. I don't know what those documents are. What are those documents?
So it's with the packet that I filed with the courts. I'm not sure. This is all confusing to me, but it is what the lawyer that Cowlitt's legal aid sent me to, and she filed all that stuff. That was what I was told I needed to file with the courts.
Okay, so you're saying that those documents that are listed there are documents that were served upon Ms. Dietrich?
Correct.
Okay, so the difficulty for me is that when somebody looks at that, they see a bunch of numbers and there's no idea what those documents are, what they mean.
Okay, they're in the packet that I filed with the courts. That's what that was the name of them, the FL Parentage, and then they all had numbers on them. They were different. I mean, I'm confused as to. I'm just trying to get my name on the birth certificate and acknowledge as I'm the father. I got the the DNA test. I went and had a paternity test done.
Right.
That's been proven that I am the father, and then I just need the courts to acknowledge that so I can get my name on the birth certificate.
Sure. Seems reasonable. So I guess the difficulty that I have, and I think it can be relatively easily solutioned, is that the proof of service, if you wanted to amend it and have the person who, Mr. Sullivan, who delivered those documents, just to spell out what those specific documents are that were served. So on that second page, you marked the box, the petition for acknowledgement of parentage, that was served. And then there's these other documents, I guess 1, 2, 3, 4, 5, 6, 7, 8 other documents that were served also. If you could just spell those out, because okay. I recognize those numbers there. That's kind of a filing system that they have on the court website. But I really don't know what those mean. And I think it's better that it's spelled out so it's clear and there's no question.
Okay.
So, and then also the motion for summary judgment, that's a 4-page document. It's unclear to me whether that was filed or not, or served. Maybe it was, maybe it wasn't. It's just unclear. I think it probably was. But if you just spell out what 301 is, what 307 is, what's 312, and the rest of those, and submit that to the court, then I would feel more comfortable that all the documents were properly served upon Ms. Dietrich.
Okay.
So I think probably what we should do is set it over 2 weeks. 2 weeks would be on the 10th of July. On the 10th of July, you will have served an amended proof of personal service. And then if with the numbers and the full title of those documents that were served.
Okay, so that means I have to, I try and get her served again?
Well, not necessarily, because if your process server indicated that they served her all those documents,
Just amend the,
comfortable with that, then they would just need to modify or amend their proof of personal service, specifying specifically those document names.
okay. And then, the name of that document that you're looking at that has, what's it called again? Because I'll have to get another one from the courts.
Oh,
or I'll have to get one off the front line.
Proof of personal service.
Proof of personal service.
Yeah, and it's FL All Family 101. Sometimes that keyword search, if you throw that into Google, under the court's website, courtswa.gov, and then you put FL All Family 101, it'll probably get you pretty close.
Okay.
So any questions, Mr. Phelps?
No, just have him amend the proof of personal service and then spell out what the documents, the name of the documents.
Yep,
correct?
Yep. So there's no question what documents were served.
Okay. All right.
And then we'll be back here. You'll need to file that amended proof of personal service, and then we'll be back here in 2 weeks on the 10th of July at 9 a.m.
July 10th.
Mackenzie Goebel, are you on the line today then? Thanks.
Yes.
Okay, welcome to you. And Ian Goebel, are you on the line?
Yes, Your Honor.
Okay, welcome to you, Mr. Goebel. All right, this is Ms. Goebel's motion for adequate cause to modify a parenting plan. It looks like I saw service occurred on June 4th, and I was just checking with Mr. Goebel. I know what Ms. Goebel's position on the issues are. She submitted documents, and I see that. And there's some a flavor of maybe what your response was, but from some text messages that were submitted by Ms. Goebel, but I didn't receive anything in particular or specific from you. Did you file anything in response to her motion?
I did not. I have been extremely busy with work, and I haven't had a chance to complete any paperwork.
Okay. And so what was your anticipation in coming to court today?
Well, we had a court date set, so I figured I should probably be here.
Okay. And is it your plan to submit something or not submit paperwork related to your position?
Will I be able to speak on the paperwork that's already been submitted, or do I need to submit anything to be able to talk?
So the difficulty that's encountered is that at this point, Ms. Goebel, she's kind of laid her cards out on the table, right? You know what she's wanting and her rationale and her thoughts. And if you were to come in today, you could say whatever you wanted to say. But number one, it's not under penalty of perjury, the statement. So that's missing. And number two, Ms. Goebel has not had an opportunity to review in preparation for review your statements or your position in preparation for today's hearing. So it kind of puts her at a disadvantage of not knowing what you are going to say, because you know exactly what she's going to say because she's already filed it all. So that's, as a general rule, that's why I generally shy away from allowing people to provide oral input at a hearing or verbal input at a hearing, because number one, statements are not made under the penalty of perjury, and number two, it's kind of springs new information on one of the parties, and it strikes me as not being fair.
I understand, Your Honor.
So Ms. Goebel has taken time away from her schedule, as have you, and so if we do set it over to a different date, can you assure me that if you want to respond, that you would be submitting something in writing and serving her a copy?
Yes, I can, Your Honor.
Okay. Ms. Goebel, let me just touch base with you as far as with your motion. You kind of heard my explanation. That I like to hear from both sides of the equation to get a full picture of what's happening. Do you have any concerns if we were to set this matter over? It would probably be a 2-week set over, which would put us at the July 10th timeframe. Do you have any concerns if that were to occur?
The only concerns that I have is of right now, we do have 50-50, and he could ask for our child, and I don't think that's the safest option for our child. So is there a temporary documentation that we can sign to put our child in my care until the next court date?
Yeah, and your concerns stem from the alcohol consumption and driving and
correct. And there's been 2 CPS reports put in, one from the school counselor, one from my son's therapist, both pretty much stating the same exact report. Also, I'm a visit supervisor, and I also did my own report. And between me and my significant other, who at the time was also a visit supervisor, and all of our reports all match. I know I've been in contact with the CPS social worker, and she went ahead. I'm not certain that they completely dropped the case, but I know that it's not a rushed case due to the fact that Ian is, our son Ian is in placement with me. He's not needing to be in a different placement. I don't know if the investigation is still ongoing.
Can you remind me the age of Ian? Or
He
a
is 10 years old.
10. Okay, 10. So your request today, and kind of an emergent basis, is for the child to be in your custody until the hearing.
Correct.
Okay. Mr. Goebel, do you have a position on that?
No, Your Honor, not at this time.
Okay. I'm going to award temporary immediate custody of the child from now until the hearing date. The child be in the custody of Ms. Goebel. I'll just draft a brief order to that effect. All issues will be addressed at the next hearing related to the motion. So let me just draft that, and then I'll read it to you so you know what it says. So the order is: the minor child shall be in the custody of petitioner Mackenzie M. Goebel beginning today and extending until the hearing set for July 10th is completed. So that will allow Mr. Goebel to submit his declaration and information that he wants the court to review, and so his voice is heard, and that'll keep the child in Ms. Goebel's care until that hearing is completed. And then on that hearing, we'll take up the motion for adequate cause and the motion to modify the parenting plan. Any questions, Ms. Goebel or Mr. Goebel?
I do. So since this is getting pushed back, I wanted to update, because now we're at the end of June, and if you looked at Exhibit F, I have all the calendars since Mr. Goebel pretty much abandoned his child, and it only goes until May. And I would like to add June in there since we're at the end of June now. Is this something that I can submit? And there's a couple other sealed confidential documents that I would like to add in from his therapist.
You can supplement your position with any filings you'd like, and you can send copies to Mr. Goebel.
Perfect.
Mr. Goebel, do you have any questions?
No, Your Honor.
Okay, we'll see you on July 10th then. Thank you. 42408.
Thank you.
Clarissa Keel, are you on the line today? Clarissa Keel, K.
Yes, I am, Your Honor.
All right, welcome to you, Ms. Keel. Devin Keith, are you on the line?
Yes, sir.
All right, welcome to you, sir. All right, so this is related to a restraining order, and it looks like Ms. Keel submitted or served an order of, let me just pull it up here. My notes are a little sketchy there, so let me just pull it up. So there was a May 10th, 2024 restraining order that was issued, and it was recently extended on June 5th to today's hearing to address the continuation of that order, whether it ends or whether it continues for up to a period of a year. So that's my understanding of why we're here today. Ms. Keel, does that comport with your understanding, or do you have a different understanding?
Yeah, no, that is correct, Your Honor.
Okay. All right. And then Mr. Keith, is that your understanding of why we're here today?
I guess that and divorce stuff is what I was understanding. I was never served with anything. I found out through like her posting on social media things. Mm-hmm. Somebody told me, one of her friends messaged me and said, "Hey, you have court coming up. You should look at your stuff." I haven't been served with anything. I haven't got paperwork from any of those restraining orders whatsoever, or divorce papers or anything.
Let me double check with you. There was a order regarding service that allowed mailing of information to be sent to Mr. Keith at an address in Astoria, Oregon. Is that your mailing address, Mr. Keith?
I don't have the PO box anymore, no.
Okay.
And I'm on the boat constantly.
Okay.
Your Honor, Devin Keith he's out on bail and he just eluded the bail bondsman yesterday. So I know for a fact he currently is not out on a boat. He ran from them. They contacted me. They've been like showing up at my house looking for him all the time. So he just does this to prolong things.
So let me just go back then to the order to allow service by mail. So that there was a motion to allow service by mail that was granted, and that occurred back on June 5th. And it has the address is 750 Commercial Street, Post Office Box. Actually, let's see, I think I got that backwards. Hold on a second. Yes, 750 Commercial Street, Post Office Box 1087, Astoria, Oregon 97103. So have you checked your post office box recently?
I don't have the PO box anymore. It closed like at the end of April or something like that.
Okay. So do you have a new address where you'd like to receive documents related to the case? Okay. So one thing that you'll need to do, Mr. Keith, you may have heard me mention this before, it's each party's responsibility if they change their address during the pendency or during the duration of a case, they need to file an updated address form with the court clerk so everybody knows where you can be reached.
Okay.
So you'll need to submit that form. Your options are to contact the clerk's office, or you could go to the court's website. It's courts.wa.gov, and then look for an address update form. And then you'd get that form, you'd fill it out with the new address, you'd submit it to the court, you would send a copy to Ms. Keel.
Okay.
So you'll need to do that promptly. And then also with the post office box, you should swing by there because it looks like it was properly delivered to that post office box. So the service is technically good. So that it's technically good that you have been properly served with notice of that. Do you know, have you checked that mailbox lately?
No, because it was closed. I haven't gone to it.
So what do they do with the postage or the mail that's in the post office box if it's closed?
I don't know. I figured they would return it to sender or something.
Okay.
Yeah, I haven't been in that area.
Ms. Gill, did you receive any return of any mailings?
I did not, Your Honor. I haven't actually received. I know there's a bunch of mail still going there for like his truck and his trailer, and they don't get anything sent back either. So I believe if someone else had that post office box, they would be sending the mail back.
Okay.
And that they wouldn't stick it in the box. To my knowledge, the post office can't deliver mail to the wrong person.
Sure. Well, let me touch base with you, Ms. Kill. As far as you use properly submitted copies of a lot of different things. You had the order extending a new court date, your declaration, immediate restraining order, and hearing notice, a variety of documents. What I'm hoping to accomplish, because I think that the service is proper. What I want to have happen is if it's possible for those documents to be emailed to Mr. Keith.
Your Honor, I also had my significant other as a courtesy email them to him as well. Let me check. That was in June sometime, or this month, I guess. That was emailed to him June 15th, and it did not get booted back.
Okay.
So,
Mr.
and
Keith,
since then, I will say the harassment has ceased.
Okay. Mr. Keith, did you receive a copy of those documents via email middle of the month?
I did not. I had to change my email. I didn't close my old email, so I'd have to log back into it and look. But because of Ms. Keel harassing me and instigating me and antagonizing me, yeah, so I would have to get back into the old email.
Okay. So I would encourage you to get into the email and find those documents related to Ms. Keel's motion for the restraining order to continue for up to a period of a year. And then once you have that, then you could respond. You could submit declarations to the court and then send a copy to Ms. Keel. And you'd also need to file a proof of personal service that you had mailed them to her.
Okay.
And then you also need to file that updated address form, which I would allow that to occur, and then you would be served at that address, at the new address that you submit, which is that Ocean Park address.
Okay, yeah, it's my mom's place because I'll be fishing. I wasn't, I paid my bail bonds. I don't know why she's saying I was chased by bail bondsmen. I haven't been in the area and I paid all my sets. I gave them a check at the beginning of the week. Last week on Tuesday, was it? I think Tuesday. Yeah, my mother gave them a check. So I don't know what she's doing with that and why she's bringing that into things, sir. That's all.
Okay. So that's where we're at. So at this point, I'm finding that service is proper, that it was served to that post office box, and that I'm allowing Mr. Keith an opportunity to review his email where Ms. Kill has indicated that she's submitted those via email, all the documents that were served before, and allow him to review that. And then we could come back in 2 weeks to receive Mr. Keith's submissions, what he wants to say about the case. He would also then be filing or sending a copy to Ms. Kiel, and then you would also, Mr. Keith, be submitting the change of address form. I'm going to, on the court's what they call sua sponte motion, I'm going to amend the order regarding service, allowing service to occur via mail at the Ocean Park address that Mr. Keith had indicated that's where he wants to receive mail and service. So as far as timeframes, I'm proposing that we'd come back in either 2 or 3 weeks. Any suggestions or comments on when we come back to hear from both parties?
If I could ask for 3 weeks, because Bristol Bay Fishing just started and I leave, and we don't get back usually until around July 21st or 24th ish, just depending. But yeah, if I could get you in a couple weeks, that would be great.
So if we were to set over 3 weeks, that'd be July 17th. So
Your Honor, I'm out of the area July 17th.
Okay. Would July 24th work better for both?
If it's between the 24th or the 17th, I could make the 17th work. I want to get this done in over.
So in extending or continuing the case to that date, I would be continuing the restraining order that was initially entered on May 10th. So it'd still be in effect. So it sounds like Mr. Kill or Mr. Keith is going to be on a ship until the 21st. So we'll be back here on the 24th of July at 9 a.m.
Good.
Any questions, Ms. Kill?
No, Your Honor.
Mr. Keith, do you have any questions?
I don't believe so, sir.
Okay, we'll see everybody on July 24th, and we'll have the hearing at that time.
Thank you.
We have Joseph Roach
Thank you.
here today. Okay, all right, welcome to you. All right, and then we also have Ms. Corey's on the line as the GAL. So I was handed some documents earlier today related to the case, so I have those in my possession. I also have it noted for today that this was Mr. Roach's motion for drug testing that you had submitted back in May 29th for drug testing. And so as the service was good, that Ms. Roach received those documents. So that's why I know we're here. That's what it's docketed for today's hearing. And then I have these proposed orders that were submitted that have signatures from both Ms. Roach and Mr. Roach that relate to a parenting plan and also to child support. So let me just touch base, see where we're at. So Mr. Roach, what's happening with the case?
I agreed on like a final order. And
okay.
All that and what I might be getting for disability for child support. And we agree on everything.
Okay. Do you have any?
She said we'd have to drop the guardian ad litem or something to be able to finalize the order. I'm not really sure.
Okay. Did you feel like you had enough time to go over all the paperwork?
Yeah, we met at a McDonald's and sat down and talked about it, and then just the other day we went and talked to a legal aid, I think, or an attorney or something like that, and she helped us through the paperwork.
Okay.
And help tell us what we did wrong or right, kind of thing.
Okay. Do you feel like there's any pressure or undue pressure or coercion for you to sign any of those documents?
Not at all.
Okay. And Ms. Roach, same questions for you. Do you feel like there's any duress or coercion or force being applied so that you'd sign off and agree to all this?
No.
Okay. Ms. Corey, did you receive a copy of those proposed orders?
I did not.
Okay.
This is also supposed to be the initial GAL review today.
Okay. Why don't we do the initial review from Ms. Corey, and then we'll talk about these potential proposed orders that have been signed by the parties. Ms. Corey, go ahead, please.
Ms. Roach has been very cooperative. She has returned her intake form, and I have an appointment set up with her for Friday, initial appointment. Mr. Roach, however, though, I mailed out the documents to him on May 30th, and because he requested them as a paper copy through the mail, I was unable to expedite that, and I have not received that back from him yet. Nor have I had any, he has not touched base with me at all about it. I did reach out to him. He said he had just gotten the intake, and I haven't seen it back. So it's been nearly a month.
Okay. And so really you don't have much information at all at this point?
Right.
Right. Okay. In your order of appointment, you were appointed back on May 29th, correct?
I believe that sounds right. Yes.
Okay. So let me hear from the parties. Ms. Roach, can I hear from you first as far as the court ordered that the guardian ad litem be appointed, and I can't remember if that was, I'm assuming that was that a request from either you or Mr. Roach?
It was offered and we both were in agreement. We didn't have any reason to not have a guardian ad litem.
Okay. Do you agree with that, Mr. Roach?
Yeah.
Okay. And did either of you send the proposed order that I have in my hands that you both signed off on? Did either of you send that to Ms. Corey?
No.
I did not, because when we had talked to the attorney over through Cowlitz, Wakayak, and Legal Aid, they had said that since we're going to dismiss Twyla, that we don't need to send her orders.
Yeah, she's been appointed by the court by order. Let's see. She was appointed to investigate and report to the court on all issues related to making a parenting plan for the children, looking at potential issues of substance abuse and any other issues that could affect the safety of the children. So the court is still interested in her input. The parties indicated that they were okay with her being involved. So let me just check on one item before I continue. I'm just going to look back at some of the notes from previous cases. Ms. Corey, do you have any input related to if the court were to sign off on these orders that have been agreed upon by the parties? Do you have any input or any concerns related to that?
I have no information really on either party other than what I've heard here in the courtroom so far. So all I've really done is send the intakes out and speak with both parties on the telephone a couple of times and set up appointments.
Okay. All right. Thanks. So we have the proposed parenting plan is for Father Mr. Roach to have the first, third, fourth, and fifth weekends, Friday, 7 p.m. to Monday at 8 a.m. And that Ms. Roach would be the primary custodial parent. Okay. And are you comfortable with that, Ms. Roach?
Yes.
Mr. Roach?
Yes.
Okay. And as far as child support, has a obligation of Mr. Roach to pay $100 a month. That sound right?
Yeah.
Okay.
We did a guesstimated what it might possibly be. I don't know.
Mm-hmm.
He's currently in a court case with Social Security income to get disability. So that's why it was an imputed income for him.
Okay.
And after this, I'm going down to Social Security to look up on it and see what's going on. They just told me it'll take a while. Last time I was there, I was like, is that a couple weeks, months, or probably 6 months or something? I don't know to tell you. It'll take a while.
Yeah, usually doesn't happen very fast. So at this point, are you working right now?
No.
You're not. Okay. How are you supporting yourself?
My family's helping me, and like side jobs here and there, and like scrap runs and stuff.
Okay. All right.
Firewood.
Okay.
Trying to sell my quad right now.
Okay. Does either party have any questions about the proposed orders that are here before the court?
Mhm.
Okay. Ms. Roach?
No.
Okay.
No, I don't think so.
Okay. Ms. Corey, any final comments?
No.
All right. I think, oh, did you have another comment?
Yeah, I was just gonna say, I have that paperwork. It has like a couple more pages that need filled out. I have to have help with it.
Which paperwork?
Otherwise you won't be able to read it.
Which paperwork?
The paperwork from the guardian ad litem.
Oh, okay. Okay. All right. Well, I think I was just taking a look at the case file to see if there was any large red flags that are waving at me, or any big concerns that might be present, or any issues of coercion or overbearing or undue influence and the like. I'm not sensing that. I'm relying on the parties to alert me of that. So as a general rule, I think as a general rule, the parties came here and said, hey, we have an issue we can't decide on, several issues related to the children. So the court started taking action related to that, appointed the guardian ad litem in hopes that that would provide any additional information. During the interim, the parties have put their heads together and have come to an agreement. So I tend to favor to allow the parties that are closest to an issue to resolve that issue through their own agreement. And if the parties can do that, then I'll allow that without any of those other signs being present of concerns. So I'll discharge Ms. Corey. You feel free to submit any billing that you'd like. And we won't need to hear from her because I'm going to sign off on the orders that were presented to the court from the parties. So I'm signing those now. Okay, I've signed off on each and all of those orders. And I express my thanks and appreciation to the parties of working through those issues and being able to come to an agreement. That doesn't always happen, and that's okay. And to the degree that both of you can continue to co-parent together and for the benefit of your children, that does nothing but help your children to have a good, solid foundation in life. So, thanks for your efforts with that, and I appreciate that. Thank you.
The guardian, the legal aid lady didn't want to talk to us in the same room. She said there's too much conflict of interest or something like that.
Okay.
But we still did all right.
You're still able to work through things and
Yeah.
figure it out. Okay. All right, Ms. Corey, any final questions on your end?
No, sir, but I would mention to Ms. Roach that we would just cancel our appointment on Friday.
Okay, thank you.
Right. Okay. Very good. That'll conclude the hearing today. Thank you. All right. Bear with me just.
Thank you.
Okay. So we have Mr. Is it Sickles or Cycles?
Sickles.
Sickles is present and Ms. Wanzer is present. This is on for a motion for temporary orders. Let me just take a quick look here. I'll tell you what I normally do with my preparations. I usually start the week prior, and then I usually have time on Monday morning to review, and then Tuesday afternoon, evening, I'm reviewing the cases. So when I started reviewing the cases on Friday and Monday, I didn't see your case noted for today. And so then when I was preparing things last night, I didn't see it there either. And I don't know why I overlooked it. So I apologize to both of you. I haven't read anything for your case. I'm usually pretty good. If I'm going to tell you if I read, and if I haven't read, I'll tell you I haven't read, and I haven't read your case. I recognize both of you because you were here previously, and I recognize that. But there was it looks like you had a hearing in front of Judge Carmi back in mid-June, where you said a mandatory settlement conference. So I really apologize. I overlooked your case somehow. I don't know what happened, but I'm not prepared. So I can't go forward today, and I apologize to both of you for the waste of your time. Could we look at resetting this to next week, July 3rd? And then that would give me an opportunity to read things, and I would call your case earlier in the docket so you wouldn't have to spend so much time here. So I'll check with you, Mr. Sickles, as far as your schedule.
I'll make it work.
Okay. Ms. Wanzer? Okay. Again, my apologies. I'm sorry. I'm sorry. I wasn't ready today, but we'll see you next week. Okay.
Before we go though, can we address, there have been some inappropriate serving?
Inappropriate what?
Serving of papers. Just before we go, can we just maybe, can we serve each other via certified mail or email instead?
So if parties want to agree to serve via email, sometimes that's a lot more convenient and less expensive. If you want to make that agreement, you could make an agreement and sign it and say you agree to serve each other by this email and this email. But there's nothing requiring either party to do that. It's a lot easier for some people. But do you have any input on that, Mr. Sickles?
Well, I would love not to be served at work, so yeah.
Okay, so email would work for you both. Maybe what I could do, I could just draft an order that says the parties are allowed to serve each other via email. And then you can both, I'll leave a spot for each of you to put in your email address, and then I'll do it in triplicate so each of you have a copy for your records.
Thank you.
Okay, so the order reads, the parties are hereby permitted to serve via email at the following email addresses. Then I have Mr. Sickles' name for a place for you to write in your email address, then Ms. Wanzer, a place for you to write in your email address. So I'll hand that down to the clerk. Mr. Sickles, if you could come up and just write in yours, and then once you've written it in, then give it to the clerk, and then we'll invite Ms. Wanzer to come up and then write in yours, and then we'll give each of you a copy for your records. And so then we'll be back next week. And again, my apologies. We'll be back here July 3, 9 a.m. Okay, thanks for your patience. So we have Mr. Warmdahl present and Ms. Mierendorf present, and Ms. Lawrence, the guardian ad litem, is on the line also with us today. So we're here for a couple of different matters. There's Mr. Warmdahl's motion for temporary parenting plan that's we're here for on that, and also discussion related to restraining order and also the GAL and looking at some dates and the like. So it looks like maybe we could start with that first, with the guardian ad litem issue first. Ms. Lawrence was appointed on May 22nd. And I'm not sure from your vantage point, Ms. Lawrence, are you needing any information related to dates or due dates or anything of that nature?
No, it's going to take probably pretty close to 8 weeks at this point before I get things back from DSHS, considering the current workload that they have, what they're telling us. But both clients have met with me at this point, and we have already started the investigation and stuff. But basically, I could note it up, or if the court wants to set a date, that's fine too.
Okay, thanks. Appreciate that. So as far as both parties have commented on the proposed parenting plan. You both have submitted your input and what you'd like to see or not see related to the parenting plan. Ms. Lawrence hasn't had full opportunity to review documents and the like to provide additional input regarding the parenting plan. So I just want to ask you both what your position is, and we'll start with you, Mr. Warmdahl, since this is your motion for the temporary parenting plan. If you feel like it's important that there be a ruling on this now related to parenting plan, or if we should wait until we get more information through DSHS and also Ms. Lawrence.
I don't mind waiting for Miss Lawrence at all.
Okay. Right now, what's happening with the parenting time? How are y'all working that?
Currently, I just have my son, and that's
it.
That's it.
Okay. All right. Thanks, Ms. Mierendorf.
I would sorry, I would like to see my son anything like an hour. I don't just anything. It's been too long.
Right.
I just want to see him.
Okay. So the restraining order was signed March 20th, 2024, and that was based on some preliminary information about the other child's passing in last February of 2023. And there was restraints placed upon Ms. Mierendorf not to assault, not to disturb peace, and the like. So it sounds like Mr. Mierendorf's main concern, well, I'm not sure. I guess what I'm leaning towards at this point is that there could be some. I want to just address parenting plan kind of on an interim basis now to maybe give a little more clarity and fine point on the potential visitation between mom and child, and then have that be in place until we come back in 2 months, 2.5 months after Ms. Lawrence gets some information. So that's kind of how I'd like to proceed today, if we could, since the motion's pending. There could be an interim ruling on Mr. Warmdahl's motion, and then we could have an additional hearing once we hear from Ms. Lawrence and the GAL. Do you have any concerns if we were to approach it that way, Mr. Warmdahl?
No.
Okay, Ms. Mierendorf? Ms. Lawrence?
Perfectly fine.
Okay. So let me just hear just briefly what your respective positions are, Mr. Mirendorf. Tell me what your concerns are and why an interim parenting plan should be one way or the other.
It should be one way or the other.
Well, your proposed parenting plan is that you have the custody of the child and that Ms. Mirendorf has no residential time or no visits with the child.
She could have visitations. I'm not completely opposed to that, but I would kind of like them to be supervised. I thought that she could still do supervised visits with her mom, but nothing has ever happened really.
Okay. And then, so to help me understand your concern related to safety. I understand that, I've read the police reports and the like, where Ms. Mirendorf was at work during the time when the child was assaulted, which eventually led to the child's death. And that was her boyfriend or significant other or spouse at the time. And tell me what your concerns are related to Ms. Mirendorf and being with your child.
It's not as much of a safety concern at all. It's just he goes to counseling and there's just it's tied to her because it was her boyfriend and stuff, and he asked where's Ducky and stuff like that, and he just is tied together with trauma. And it's not I'm afraid she's physically going to hurt him. It's just it brings back stuff and it hurts all of us in my household.
Mm-hmm. And you said the child's in counseling?
Yes.
How often
He goes a couple times a month, probably. Like, he sees Connie.
And we're talking about Elias, right?
Yes.
And how is he, 3 or 4?
He's 4.
He's 4 years old now.
He'll be 5 at the end of this year.
Okay. And if Elias needed additional support, if the visits were started with mom, would you be in a position to make sure he gets to those appointments?
Yeah, I have a fairly busy schedule, but yeah.
Okay. All right. Thank you. Ms. Mirendorf, tell me what your position is. You've indicated that you're hoping for, I think, a 50-50 plan, maybe? Yes. And then, okay, why don't you go ahead and tell me what your thoughts are?
I at the end of the day, it doesn't really matter to me what it is. I just want to see my son. I would like to do 50-50 because I just feel like all this is being based off of a crime that I did not commit. And I didn't know. I'm sorry. And sorry. When my son was hurt, I didn't know. I would have done anything to prevent that from happening. I'm sorry that it happened, but I was working, and I know I should have been home, but I just don't want to be blamed for something that I didn't do. I just want to see my son. It's not fair to me.
When was the last time that you had contact?
Christmas.
Christmas 2023. Okay. And as far as what's your input as far as supporting Elias if I were to allow visits? What do you think would help Elias?
I would like it to be unsupervised just because my mom isn't available all the time. She's only available for 1 day a week, and that's Sundays. Mm-hmm. And she's only available from 12 to 4.
Okay. And is Elias enrolled in daycare or preschool or Head Start? Okay.
I mean, he's enrolled, but he's not in it yet.
Okay, he's signed up.
Yeah.
Okay. And when does that start?
I have no idea. I gotta go through all my emails.
Okay. So, but he's not in it currently.
No.
Ms. Lawrence, do you have, I know this is very early in the process. Do you have any input at this point?
I don't have too much input because, as you said, I don't have all the information, but I think that it appears that there's no physical safety to the child. I agree that Ms. Mirendorf should be able to see her child, but trying to do that in a safe manner that makes Dad comfortable, because Dad got rattled too. With all of that, it's a very frightening situation. It's a horribly sad situation all the way around. So I would advocate for visitation and what that could look like. I mean, maybe start out slow But it could ramp up fairly quickly, I would think.
Okay. So I think what's important to highlight here is that there's no allegation or no allegation that Ms. Mierendorf is a danger or a physical risk to Elias. That there was a crime committed, a horrible crime that was committed. She was not present. She was not implicated. There was no charges brought against her. It was her boyfriend or significant other at the time, and he's serving prison time currently. So I think that's important to note at the outset. I think it's important also to note that Mr. Warmdahl is taking good steps to make sure Elias is supported with his mental health. I think that's really important. So good for you and good for Elias that that's happening. So I think what will happen between now and the next court hearing, which we'll set here in just a bit, the following residential time for mother. So I want to have 2 midweek visits or 2 visits during the afternoons from 4 to 8 p.m., one on Monday, one on Wednesday. And then another visit on Sundays from noon to 4. At this point, I don't think they need to be supervised. I recognize that there may be some big emotions from Elias that may be present. And, maybe that 4 hours doesn't happen the first time or the second time. Maybe it needs to be cut short. I don't know. But my sense here is that there's no physical danger. There's mental health support for Elias. And I think that should start this coming Sunday from noon to 4. And then it would beginning the Monday and Wednesday, 4 to 8 p.m. And I'm just kind of throwing that out there initially. But my intent is to have 3 visits per week. With 1 on Sunday for sure. But the other 2 days, whether it's a Tuesday and a Thursday or a Monday and a Wednesday, I want to give you that flexibility as parents because I don't know your schedules and things happen. So any feedback on that proposed schedule, Mr. Warmdahl?
Weekdays being in the evening sounds okay, and
Okay.
Sunday is my day off, so.
Okay. All right. Ms. Mierendorf?
For the weekday for both visitations, if possible, can I request that just me and him for pickups and drop-offs? There's too
Meaning
much
you and Mr. Warmdahl?
Yeah, just me and him, no other people to come. His girlfriend just causes a lot of conflict.
Okay. Any concerns about that if we were to do that? Just that anytime that there's an exchange, it would be the you two meeting someplace, exchanging your child, and then going your separate ways.
Yeah, if that could be written in, that would be fine.
Okay. All right. I'll do that. Let me draft this so you each have a copy. This is what the order reads. This is an interim order related to residential time. Petitioner Warmdahl is deemed custodial parent. Respondent Mierendorf shall have residential time with a minor child on the following days and times: Monday 4 to 8 p.m., Wednesday 4 to 8 p.m., and Sunday noon to 4 p.m. At the exchange of the child, only the parents and child shall be present. So we'll give each of you a copy of that for your records. Let's look at a next date for us to come back. Ms. Lawrence has indicated 8 weeks minimum for records from DSHS to come back. So today's the 26th. That would put us to end of August, which would probably put us wisely to maybe September 18th or September 25th for the guardian ad litem report to be submitted. Any comments, Ms. Lawrence, on that? Is that too rapid of a turnaround after the 8 weeks?
I think that September 25th would work fine.
Okay. How about for the parties, Mr. Warmdahl, to come back for the guardian ad litem to submit her report, provide you a copy, and come back to comment on it, see if there needs to be any adjustments to the parenting plan?
Yeah, on the 25th is fine.
25th September. Okay. Ms. Mierendorf?
That's fine.
Okay. September 25th will be the date we come back. That'll be at 9 o'clock in the morning. Each of you will get a copy of the order. And again, the visits will start on this coming Sunday. So we'll see everybody then. Thanks.
Thank you, Your Honor.
Thank you. 4314508. We have Mr.
Yes, Your Honor. This is Beth Fellows, guardian ad litem.
Thank you, Ms. Fellows. We have Mr. Knuth is present, and then we have Ms. Bender is also here. This is a review hearing, and let me just pull up my notes on this. So the family court investigator submitted a report as of May 17, 2024, where she detailed some facts that she sees saying are present. And then Ms. Fellows was subsequently appointed, I think at that same time frame thereabouts, or there was a recommendation that she be appointed on May 17th, and she's been subsequently appointed. I haven't received any information from her as of yet. I think her report is due end of August, sometime August 28th. So we're here today for, I guess, kind of a interim review, check base with Ms. Fellows, hear some feedback from the parties. I'm not seeing any particular motions have been filed by either party. I know that there's concerns, both parties have concerns about the other. So maybe we could just lead off and hear from Ms. Fellows, and then we can hear from Mr. Knuth and Ms. Bender. Ms. Fellows?
Yes, Your Honor. I was appointed on May 22nd. I did get the contact information from the family court investigator for the mother. I sent out the intake packet. I have received it back from the father. I did call the mother to get her actual address and did talk to her a little bit and then sent out the intake packet. I have not heard back from the mother or received the intake packet back yet. So I'm kind of at a standstill. What I can say is I've also done a review of Odyssey. There's quite a bit of criminal history on both mom and dad. Some of the information that the family court investigator provided to me about the boys, Gunnar and Odin, there's a lot of concerns and there's a lot of investigation that needs to be done. I'm actually asking for a 30-day review to be set for July 31st. Due to the holiday, I pushed it out a week. So we could kind of check in again because I haven't heard from mom. And so I'm kind of stuck there. She's there in the courtroom, not sure why I haven't heard from her. The intake packet has not come back, so I'm thinking that she got it. That's kind of where I'm at, but there are a lot of concerns that I need to investigate. So I would have to say that an August date, I would have to push it out. But again, I would like to have that review on July 31st. Just a 30-day review to check in.
Okay. Thank you, Ms. Fellows. Maybe Ms. Bender, maybe I could ask that question of you. Did you receive the intake packet, and what are your plans to get that back to Ms. Fellows?
I did receive it. I have it with me right now. It's filled out. I don't know where to turn it in at.
Ms. Fellows, where would be the best place to get that to you?
The address is on the intake packet of my office. I am here now, so after the court hearing, you can swing it by.
Okay, thank you.
Okay.
Thank you.
Thanks. Mr. Knuth, any comments on Ms. Fellows' report or comments?
I have a couple of concerns. Number one, I understand that Ms. Fellows is waiting on information, so her hands are kind of tied at this point. But as we haven't done our interview, I expected her standpoint to be, we need to look at this at a later date so that we're in agreement on. On top of Father's Day being this month, all three of my kids with Miss Bender are birthdays this month. As I raised these children on my own from 2015 until January of this year, I would like to know what it would take to get phone visits until Ms. Fellows has time to complete her investigation. And last time we were before you, you told Ms. Bender that she needed to provide me copies of the documents she served you. And I still have not gotten those. Those are my three concerns, things, subjects, topics that I wanted to bring up today.
Okay, thanks. Maybe we can just go in reverse order. Ms. Bender, as far as documents that you filed, are you making sure that you're not only filing them, sending a copy to Ms. Fellows, but also sending a copy to Mr. Knuth?
Honestly, I forgot, so I will do that.
Okay, that's really, really important because the system only works when both parties know what the other party is saying, and the court knows that both parties know what the other parties are saying. So do you have an address where you can make sure Mr. Knuth can get those documents?
Just send it to the 217 25th.
Still in the same house I was in many months ago.
All right. And then as far as phone visits, Ms. Bender, do you have any insight or opinion on that?
I don't mind phone visits. That's fine.
Mr. Knuth, do you have suggested times, frequency?
At least once a week, and since the children in question are 14 and 15, going to be 16 the end of the month, the children should be allowed to pick the time between, say, 4 and 8 o'clock at night. They can pick the time and day as long as it's at least once a week.
Okay. I'm fine with the phone visits. I think it's, you know, I don't want to unduly limit it. I would say up to 3 times a week, but again, kids are kids and they're busy, and so you know what their schedule is. But I think up to 3 times a week, I don't have any issues with that. I don't have any sense that Mr. Knuth is going to abuse that or it's going to cause any harm. You know, I don't have any concerns about that. So between 4 to 8 p.m., 3 times per week, whatever that you kind of agree upon. I can set specific dates if you can't all agree on a particular date and time, or the kids, if it would be helpful, we could say, you know, Monday, Wednesday, Saturday, or Tuesday, Thursday, Sunday, something like that.
Can we say if it's consistent, the children pick the dates, and if it's not consistent, we will review it at the 30-day review for Ms. Fellows' information?
Ms. Bender?
Yeah, that's fine.
I think that's fine. Okay, so Ms. Bender, you're going to get documents to Ms. Fellows. You're also going to get documents to Mr. Knuth. And then the phone visits, I'll just do it just a brief bench order related to that, so that's clear about the phone visits. And then there was a third item you said, because we addressed 2, and I'm not sure if we addressed, you talked about the review on the 31st.
The fact that you appointed an investigator who said it was too complicated for the timeline they were given, and then Ms. Fellows was appointed. And since I haven't done an interview with her, I assume she hadn't done one with Kimberly. And then Ms. Fellows brought up the lack of packet.
Right. Okay. Thanks for that review. In drafting this order regarding the phone calls, up to 3 times a week, do I specify the time, or just say it's at a time chosen by the children?
Chosen by the children works.
Ms. Bender? Okay. All right, thank you for your patience. The order reads, Petitioner Knuth may have up to 3 times a week phone visits with the minor children at a time chosen by the children. This order may be reviewed at the next hearing on July 31st, 2024 at 9 a.m. So I'll give a copy of that to each of the parties, and we'll set the matter over to the 31st of July at 9 a.m. For review. And it sounds like Mr. Knuth is following through with the GIL, so I appreciate that. And it sounds like Ms. Bender is going to be following through with the GIL, getting her information, and so the GIL will be in a position to provide some detailed information come the 31st of July. Any other items from you, Ms. Fellows? Then we'll check with Mr. Knuth and Ms. Bender.
No, Your Honor, thank you.
Okay, Mr. Knuth?
Not at this time.
Okay, Ms. Bender? All right, well, if you come forward and get the copy of the respective copies of those orders, and then we'll see you on the 31st of July. Okay, both parties are present, taking a seat. Ms. Keegan is present, Mr. Trotter's here. Okay, thanks for your patience for being here 3 hours this morning. So this is a motion for temporary orders. Couple of different things, just looking at this. My notes here indicate that there's a desire by Mr. Trotter to have some visitation, and some desires by Ms. Keegan to have a house inspected. And I think Mr. Trotter kind of alluded to that, probably needed to get things kind of cleaned up a little bit. So that's one item. The other item is joint decision-making, and then also visitation timeframes. So that's kind of what I've read, which I think is on your minds. And so let me just touch base with you both. Ms. Keegan, as the petitioner, do you have other items that you want to have addressed today?
So we've kind of come to an agreement on both the parenting plan and the child support amount.
Okay.
It's just right now we didn't turn anything in because it's not ready to be turned in. He's not prepared to take him until he said he'll be able to buy everything by the 10th of July for Brooks, our son.
Okay.
So after that point, I was hoping we could schedule like the last hearing for the 17th
of July.
And that way we can finalize everything as far as the parenting plan, since he will be able to take him after that date.
Okay, thank you. Mr. Trotter, any input, anything in addition to that?
No, that's pretty much spot on. We talked about everything you talked about, and we filled out the child support thing, and we both signed that. Okay. And talked about the parenting plan, and it's pretty much what you said. It would take me a few more weeks to get everything together that I need in order to properly accommodate him all day. And so
okay.
disagreement with anything.
Okay, all right, great. And are you comfortable if we were to set a hearing for July 13th, just for entry or finalization of the parenting plan and child support?
For the 13th?
I think that was the recommendation.
I thought it was only Wednesday, so I think that was the 17th. I wasn't, is that?
Oh, yeah, I
Yeah.
I misnoted. Yeah, 17th.
Yeah.
Yeah, okay. All right. Well, I appreciate the parties working on those items and kind of figuring things out. That's much appreciated. We'll set it to July 17th for finalization of the parenting plan and child support.
I did have a couple questions, just two, regarding the child support.
Go ahead.
There was a few things I left blank on it. I'm gonna get it all turned in this week, for the next hearing so that it's on file and prepared. But as far as the section where it asks about, how the payment will be received, am I just supposed to get it from him when he transfers it? Because I don't think the state gets involved in that unless he weren't to be paying, I would take him back, correct?
So my understanding, and I may be wrong, is that obviously parties can transfer monies in between each other directly. Some people do it via Venmo. Some people do it through cash or through direct deposit. I've seen that, and also a check in the mail too, or cash with receipts. Then the other option also would be, I've seen where people will use the Division of Child Support to have kind of third-party receipt the monies and then forward it on to the other parent. That way, if there's concerns that the monies aren't being properly accounted, then there's a third party that can say, yeah, we got the money on such and such a date and we forwarded it on such and such a date. So at least those are my understandings of potential mechanisms to transfer payment.
Okay, and then as far as we came up with an agreed amount, but as far as like medical, dental, vision, and all of those extra costs that could come up, how does that work? Like are we just supposed to discuss that, and then if we were going to do 50-50 with it, I would just ask him for that, or how does that work? Like,
so generally, what is generally seen with with child support orders, if there's other costs, whether it's extracurricular or daycare or non-insured items, then there's two ways to do it. One, there can be an agreed upon percentage, or it could be just based on the percentage of incomes between whatever your income's, like 56% or 44%, and there would just be a percentage of the cost that each would be divided to each parent.
okay, that makes more sense now, because we were going to do the percentage, but we filled out the percentage on here. Is there like a calculator for the percentage, or do we just come up with that on our own too?
I think there's a child support worksheet calculator that will calculate and it'll tell you what the percentage is.
Okay. Okay.
Yeah, I think if you do a Google search and make sure it's Washington State child support calculator, that it'll pull up that information for you.
Okay.
Any other questions?
Nope.
Mr.
That was
Potter?
it for me.
Great. We'll see everybody on the 17th of July.
Okay, thank you.
Great. Thanks.